I'm criminal defense attorney Aaron J. Boria, and today I'm going to talk to you about a change in law that encourages you to be off probation early. Prior to this law being passed, you've always been able to file for early termination of probation. But under the new law, the legislature, the people that wrote this law, they really want courts to grant it. Under MCL 771.2, the law says that at sentencing, when a judge orders you to probation, they need to tell you that at the halfway point, you are eligible to file for early termination of probation. The law goes on to say that you need to be supplied a form by the court if you want to file for this early termination yourself at the halfway point. When deciding whether or not to grant this motion for early termination, the court is not required to hold a hearing. They can simply grant it in writing and let you go. But if the court decides not to grant your motion, a hearing needs to be set so that you have an opportunity to explain to the judge why you think you should be released from probation early. Additionally, if the only thing you haven't done is paid your fines and costs, but you have made best efforts to pay them, a court cannot hold that against you when deciding whether or not to grant early termination. Now, restitution's a little different, but they can still grant it if you have made efforts to pay your money. One of the things that you need to take into consideration is if you've had a violation in the past 3 months. If you've had a violation in the past 3 months, a court can hold that against you and use that as one of the reasons to deny an early termination. But look at what the legislature is trying to do here. They're forcing the court to tell you that early termination is an option. They're forcing the court to provide you with the form that you can file. They're making it easier for the court to grant it because they can grant it without holding a hearing, so you aren't backing up their docket. But they're making the court hold a hearing if they decide they're going to deny you off the bat and they have to hear you out. There's never been a better time to file for early termination of probation than now. There are a lot of reasons why a court would want to grant this, and the legislature is encouraging it. Not all offenses fall under this new statute though. For instance, domestic violence does not. You couldn't file based on this statute to have early termination on a domestic violence case. Now, with that said, there's been case law for years that says a judge has the ability to modify a probation term at any time. So I believe that even if your offense isn't included under this new statute, I believe that under that case law, it still is. It may not be granted as easily. You may have more of an uphill battle, but you do have a legal argument. And I think that a court has to hear you and consider you for early termination on that, even if your offense doesn't fall under this statute. So what are the obvious benefits to early termination? Well, the obvious benefits are you're not on probation anymore. The court doesn't have jurisdiction of you. The looming threat of jail is no longer being held over your head. You get to move on with life. I'm criminal defense attorney Aaron J. Boria, and if you are on probation here in Michigan and you want to be off early and you want help filing, call me today. I can be reached at 734-453-7806 or shoot me an email at borialaw@gmail.com. I am happy to fight for you.